Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer, and I want to go over this case from 2004, Johnson versus MBNA, America Bank. So just think of it as Bank of America. And this is a very, very important case. It's maybe the first case that really set forth at a appellate court level what type of investigation does a furnisher of information to a credit bureau have to provide when the credit bureau notifies the furnisher, the credit card company, hey, the consumer disputes this? What do they have to do? Is it just, like a 2-second glance, or do they have to actually do an investigation? And so this is, like I say, very, very important case, still referred to today, 16 years later. And so let's take a look at this. And so we'll just go through and I'll highlight information that I think is interesting. So we have the credit card company, MBNA, is appealing a judgment following a jury trial, and the jury found in favor of the consumer, saying that the credit card company violated the FCRA. Now, specifically, it's this section 1681 S2B1. Okay. Now, it's a little obscure, but it's just really important. Section 1681, that is the Fair Credit Reporting Act. And then we have all these different sections in there. Now, there's also an alternative numbering system, but this is what the courts use, section 1681. And then we get to S-2, and that concerns furnishers of information. So those who provide information to the credit bureaus. And S-2A talks about all the obligations of the furnisher in providing information. Unfortunately, you can't sue on that. And we'll even see that's mentioned in this opinion. But S-2B says when a furnisher is notified by a credit bureau that the consumer disputes, now these are the obligations that the furnisher has. So that's what this trial was all about. And so the allegation was that the credit card company failed to conduct a reasonable investigation of the consumer's dispute concerning an account appearing on her credit report, and the court doesn't make us wait. They simply say there's no reversible error. We affirm. In other words, we uphold this verdict. So here we have an account was opened in 1987, and the parties disagree about who actually applied for this loan. And the significance of that is who was legally obligated to pay on it. So everybody agrees that we have this Edward Slater. Okay, and that's who the consumer was married to. He definitely applied. Now, the bank says, hey, Johnson, the consumer, was a co-applicant, and therefore you are equally responsible. But the consumer, Johnson, says, no. I wasn't an owner of that account. I was merely an authorized user. I was not a co-applicant. And as an authorized user, I'm not responsible for the money. Okay. So what happens? Well, and apparently there was a divorce. So the person that everybody agrees was an applicant filed for bankruptcy. And so the credit card company takes his name off the account. And then they turn to now the ex-wife and they say, hey, guess what? You owe $17,000 on this. We want you to pay it. So what does she do? Very smart. She gets her credit reports from the 3 credit bureaus, Experian, Equifax, TransUnion. And remember, as I'm recording this now, in late 2020, we can get our credit reports for free through annualcreditreport.com once a week. Now, we can always get them once per 12 months from each bureau, but now we can get from each bureau once per week through about April of 2021. Just go to annualcreditreport.com. So she got her reports and she looked at them and she said, hey, I don't owe this MBNA account. I'm going to dispute it with the credit bureaus. So what did the credit bureaus do? Well, this is what they're supposed to do. They sent to the furnisher, the credit card company, an automated consumer dispute verification, ACDV. Now, I'll also say this. The credit bureaus are supposed to do their own investigation. It may be that there was not enough information for the consumer to sue the credit bureaus. Or maybe she did, and then they settled, and all that was left was this credit card company. I'm not sure. But a credit bureau has to do their own investigation, but part of that is if they need to, they send to the furnisher an ACDV. So the ACDVs, let's highlight this, that Experian TransUnion sent specifically indicate Johnson was disputing she was a co-obligor. Consumer states belongs to husband only. Okay, so maybe they weren't divorced at the time. I'm not sure. And then you can see here was never a signer on account, was an authorized user. And then what Equifax sent said she disputed the account balance. Okay, which may be true in a sense, but it doesn't give the full picture. So what did the credit card company do in response to these? So they reviewed the account information in their customer information system, CIS. In other words, they just looked at their own computer records, and you could think of, you might have a contact list, or you might have a CRM, customer relationship management software, and it just tells you the information, but it doesn't give you the actual sort of underlying documents. And they say, well, based on that, we verified it's correct. And so the credit bureaus kept reporting it. So the consumer sues the furnisher and says, look, you violated 1681 S2B because you did not do a proper investigation. And so there's a jury trial. And at the end of the consumer's case, which is very typical, MBNA moves for judgment as a matter of law. All that's saying is, hey, judge, there's no reason to let this go to a jury. You, the judge, can rule as a matter of law that we win. And the judge denied that. And then at the close of the evidence, then there would be jury instructions and closing arguments, and then the jury would deliberate. And the jury did all that, and they said, hey, we find this credit card company negligently, so apparently not willfully, which can allow for punitive damages and statutory damages, but they said they negligently failed to comply with Fair Credit Reporting Act, and they awarded $90,000 in actual damages. So what did the credit card company do? So they renew their motion for judgment as a matter of law. So after the jury renders its verdict, the credit card company says, well, look, judge, you made a mistake letting it go to a jury. You should fix that. Just go ahead and enter judgment in our favor. Because this law only requires us to conduct a cursory review. That's all we have to do. And then they say, well, even if the law requires us to conduct a reasonable investigation. So let's stop there. Make sure we understand the difference. They're saying we don't have to do an investigation. We don't even have to do a reasonable investigation. We just have to do a cursory review. But they say, okay, even if we have to do a reasonable investigation, we met that. Okay. So the judge denies the motion and says, look, there was sufficient evidence that you failed to do a reasonable investigation. So let's look at the arguments that the credit card company is making. So they say first, the first error is we should not have to conduct a reasonable investigation. And then the court says, well, let's look here at the law. 1681 S2B1 imposes certain duties on a creditor who has been notified. And that's key. You have to be notified by the credit reporting agency, sometimes called the consumer reporting agency. You have to be notified. A direct notification from the consumer does nothing. Okay, it has to come through Equifax, Experian, TransUnion, Innovis, SageStream, any number of credit bureaus. Okay, that you're disputing information. Now, after you receive notice of a dispute regarding the completeness or the accuracy, that's why we always harp on, we're looking for errors, and errors mean it's incomplete information or it's inaccurate information. And that says of any information. So we had a recent video on the argument that these companies will make. They'll say, but judge, the information that they dispute, it's not really that important. It doesn't matter. We shouldn't have been sued on this. Well, notice what the law says. Any information. So does any information mean like 20%? Or maybe it means 50%. Or maybe it's 80% or 90? No, any means you can dispute the completeness or accuracy of any piece of information that's provided. If it's unimportant, they wouldn't provide it. Okay, so if they provide it, it's important. You can dispute it. So when a furnisher, that's the person here, when they get this information, what are they to do? Well, here's some requirements. So conduct an investigation with respect to the disputed information. That's important because if we don't challenge the balance, okay, if we just say, hey, you say I was late, I was never late, and then we come back and go, well, you should have investigated the balance. Well, we have to tell them what we're disputing in order to trigger an obligation for them to dispute. Then they have to provide all or review all relevant information provided by the Consumer Reporting Agency. That would be these ACDVs that we talked about. So consumer states belongs to husband only, was never a signer, dispute account balance. Now, I'll say this, as I'm recording this in 2020, the bureaus, by and large, will forward your entire letter and all the attachments to the furnisher, okay? But look, if they don't do that and they mischaracterize your dispute, well, then you may need to be suing the credit bureaus instead of the furnisher. And normally, in most cases, we're suing both, okay? And then report the results to the Consumer Reporting Agency. And then this says, if the investigation, so of course that implies there is an investigation, like it says up here, finds that the information is incomplete, well, what do? Well, you report those results to all the consumer reporting agencies. What if you find that it's inaccurate? Well, you report that to all the agencies. So remember, you can challenge the completeness or the accuracy of any information. And if they find that it's incomplete or inaccurate, then that should be reported to all the bureaus that this credit card company reports to in the first place, okay? And then there's been a few changes in the law, and you can read about that in the footnote that we kind of skipped over here. And so MBNA says, well, look, when it says conduct an investigation, that's only a minimal duty. Just briefly review our records to see if it's correct. So stated differently, the credit card company says that this does not contain any qualitative component. So in other words, as long as we say we did an investigation, even if it took us 2 seconds to just like glance at a computer screen, you can't challenge that. You can't second guess us. No court or jury can possibly pass judgment on us. Well, the consumer says, no, that's not right. You have to do a reasonable investigation. And in 2004, when this opinion came out, you see this footnote. It says, neither this court nor any other circuit court, those are the appellate courts and federal court, has addressed the extent to which a creditor must investigate. However, district courts have consistently held it must be a reasonable investigation. So they say, look, we're going to review the statutory interpretation de novo. In other words, we'll look at it on our own. So we're not going to be bound by what the district court, the trial court said. We'll decide on our own what this means. Okay, and you can see the footnote. There's just a bunch of cases here. So how do we do this? In interpreting statute, we must first determine whether the language at issue has a plain and unambiguous meaning. Okay, so our inquiry, let me get this where it will highlight again here. So our inquiry must cease if it's unambiguous and if the statutory scheme is coherent and consistent. And then the plainness or ambiguity of a statutory language is determined by reference to the language itself, the specific context, and the broader context of the statute. And all this is saying is, look, if we can read the law and it's pretty clear, well, then we just go with that. Now, if it's not clear, then we have to start going to some outside sources to figure out. So the key term at issue, investigation, is defined just in a regular dictionary as a detailed inquiry or systematic examination. So then they say, well, let's look and see what Webster says. Investigation is a searching inquiry. Thus, the plain meaning of investigation clearly requires some degree of careful inquiry by creditors. And then they say, look, this law 1681 S2B uses the term investigation in the context of what? Of articulating a furnisher or creditor's duties in the consumer dispute process outlined by the FCRA. And they say, look, it'd make little sense to conclude that in creating a system to give consumers a means to dispute and correct inaccurate, and I would add, incomplete information, Congress used the term investigation to include superficial, unreasonable inquiries. Remember, that's what the credit card company was saying, is we don't have to do a reasonable investigation. We can do an unreasonable investigation, and you can't second guess us. And they're going, that's crazy. Look at this 11th Circuit case, which is a pretty important case from the 11th Circuit, 1991. And it says, interpreting analogous statute governing reinvestigation of consumer disputes by the actual agencies, okay? So this would be under the law 1681I, okay, which involves when you go to Equifax, Experian, Trade Union, they have their own obligation to investigate. And back in 1991, the 11th Circuit saying, guys, you have to do a reasonable investigation. And here's something from the 5th Circuit, 1986, same thing. And so they say, here's our conclusion on this first argument. Remember, the first argument is MBNA says, we don't have to do an investigation and you can't second guess us. And they say, we therefore hold 1681 S2B1 requires creditors, or again, furnishers, after receiving notice of a consumer dispute from a credit reporting agency, conduct a reasonable investigation of their records. Okay, so they have to look at their own records to see, can this information be verified? So what's the next argument? So next argument is the credit card company says, okay, if we have to do a reasonable investigation, there's no evidence to support that our investigation was unreasonable. And they say, well, we must review the evidence in light most favorable to Johnson, draw all reasonable inferences in her favor without weighing the evidence or assessing the credibility. In other words, the appellate court's not supposed to say, let's use a simple example, a car wreck. And the plaintiff said, I had the green light. The defendant said, no, I had the green light. And the jury finds in favor of, let's say, the defendant. Well, the appellate court's not supposed to say, well, looking at the testimony, we kind of think the plaintiff was telling the truth, so we're going to reverse that. No, that's not the job of an appellate court. And here they say we must view the evidence in light most favorable to the consumer because she wasn't the one moving for judgment as a matter of law, and draw all reasonable inferences in her favor without weighing the evidence or assessing the credibility. So here's another way of saying it. Question is whether a jury viewing the evidence in light most favorable to Johnson could have properly reached the conclusion reached by this jury. And we must reverse if a reasonable jury could only rule in favor of the credit card company. If reasonable minds could differ, we must affirm. And then they say, well, let's look at this. So MBNA was notified of the nature of her dispute. Hey, I'm not a co-obligor on the account. But what did they do? So let's look and see what they did. Primarily limited, number one, confirming the name and address listed on the ACDV. Remember, the ACDV is what the credit bureau sends to the furnisher. So making sure name and address was the same as the name and address in their internal system. And number two, noting that their internal system contained a code saying she was the sole responsible party. That's it. That's all they did. Okay? They didn't do anything else. It's incredible. Remember, she's saying, hey, I am not an obligor on this. I never applied for this. Well, did they go back and look at the application? Nope. Did they go look at any other documents? Nope. All they did is say, well, our computer screen says you do owe it, so there you go. That's our investigation. And what else did they do? So in investigating consumer disputes, they generally do not look beyond the information in their own computer system. And again, this is just like a screen that would just have, the debtor's name, the debtor's address. That it wouldn't have the actual document. It's not like they could click on the PDF and look at the application, or if they could, they didn't do it. So they did not look beyond the information contained in their own system and never consult underlying documents such as account application. Isn't that amazing? You say, look, I'm not a co-applicant on this. And they go, we refuse to look at the application because you know what? That would tell us the answer. So they say, well, obviously a jury could reasonably conclude that you acted unreasonably in failing to verify the accuracy of the information in your CIS. And then here's something that's interesting. They're only required to confirm 2 out of 4 pieces of information in that CIS. So what are the 4 things? Name, address, social security, date of birth, in order to verify the account holder's identity. Guess what? The consumer's social security number and date of birth were not there. Well, yeah, they would only be there if she applied. I mean, this other stuff would be there for everybody who's an authorized user. Okay, that would make sense that you would have the name because you got to issue a card in their name, and authorized users not always living in the same address, so you would want their address. So what the credit card company did here is it's sort of rigged that they would never find that you were not an actual applicant. Instead, you're just an authorized user. So that's how it's set up. Well, let's look and see what else they say here. They say, well, look, the other information compels the conclusion that it was reasonable. So they say her last name had been changed following her marriage and that her name was listed. Okay, what does that mean? And the court points it out. It says, well, it's equally consistent with the consumer's argument that she was only an authorized user and that if you list me as a co-obligor, you're incorrect. So the court's saying, look, there's evidence. A jury could go either way on this. So the fact that they supported the consumer, we're not going to reverse it. Frankly, it'd be the same if the consumer had lost. They would say, well, yeah, I mean, we could see your argument, but it's also equally likely a jury could rule in favor of the credit card company. And this is kind of funny. Just this argument, during her conversations following his bankruptcy filing, she attempted to set up a reduced payment plan and change the address. Well, a jury could reasonably conclude that she just tried to make payment arrangements even though she had no legal obligation. Look, you're saying I owe $17,000. I may dispute that, but I can also try and set up payment arrangements. Okay. And then she also says, I always told this credit card company I was not responsible. So you can do 2 things at the same time. You can say, I'm not responsible, but look, I don't want you guys suing me. I don't want you trashing my credit. Can we work something out? So here's what MBNA says next. And this is kind of a legal word, so let's talk about this. They say, failed to establish the alleged inadequate investigation was a proximate cause of her damages. Proximate cause means this is the direct result of the bad conduct. So let me give you a car wreck example. Okay. So somebody runs a red light, hits me, and my leg breaks. Well, that's the direct cause. Sometimes we call that the but-for cause. But for them crashing into my car, my leg would not be broken. Well, proximate cause is going to be a little bit less usually than the but-for cause. So in this situation, it would be the proximate cause. In other words, kind of put it next to, we have running the red light and my leg being broken. Well, those are next to each other. That's the proximate cause. Well, what if I then go to the hospital and the doctor says, we have to amputate your leg because it's so horribly broken, and he cuts off the wrong leg? Well, again, that would be but for. But for that guy running the red light and hitting me, I wouldn't have my leg amputated. Well, is it the proximate cause? Well, yes, it is, because he put me in that situation where I was exposed to medical malpractice. Well, what if then my best friend calls my 117-year-old grandmother and says, hey, John just had his leg amputated. And she goes, oh my goodness, and she has a heart attack and dies. Well, we could say, but for that guy running the red light, the call never would have been made. My 117-year-old grandmother would not have died. but that's not going to be the proximate cause because it's too far removed. So that's what MBNA is arguing. They're saying, look, if we did a lousy investigation, that's not the cause of your damages. Well, why? Because there are no other records we could have examined that would have changed the results of the investigation. And they say, look, we have a 5-year document retention. And so we didn't have that application. We threw it away. Okay? Now, this is not really, they're using the wrong terminology. This is not the proximate cause. Okay? This really just goes to reasonableness. But it's important that you understand that proximate cause concept when we're looking at damages, because a lot of cases, whether personal injury or these consumer cases, they turn on proximate causation. But let's see what the court says. They go, look, a jury could reasonably conclude that if you had investigated the matter further and you determined you don't have the application, you could have at least informed the credit reporting agencies that you cannot conclusively verify that you're the co-obligor. Okay? And so let's notice here what 1681I says. And again, some of these laws have changed. 1681 S2B's changed a little bit, but this will give us the concept here that if the dispute information cannot be verified, the agency shall promptly delete that item from the file or modify the item as appropriate based on results of reinvestigation. Now, this is when the credit bureau is doing its own investigation, but there's a parallel when the furnisher says, hey, we can't verify this information, then they should tell the credit bureau that. So there's a footnote we won't look at right now. And then they say, well, next there's arguments about the jury instructions, okay? And we won't go through all that. It's interesting. I want you to read it, and you can just Google Scholar and find this Johnson versus MBNA. You can type in 357 F3D 426, and it'll bring up this Fourth Circuit case. And a very, very important case. And I want you to see it for a couple reasons. One, to see the arguments that these companies make. I mean, can you imagine that argument where they go, we don't have to do any investigation. We just have to look at our computer screen for 5 seconds. That's all we have to do. You know, when it says investigation, it doesn't mean investigation. And then they lose that. They go, okay, well, we did a reasonable investigation by just looking at our computer screen for 5 seconds. You know, we don't have to look at the underlying document. Yeah, you do. Well, we can't look at the underlying documents because we threw them away. So therefore, you, the consumer, had to be punished because we're going to keep false information because we threw away the documents that would prove. See, that doesn't make any sense. And so, very important case. Hope you found this helpful. Feel free to share this with anybody that maybe is dealing with credit report errors and they're struggling with a furnisher not doing a proper investigation. This is a good first case to read to kind of get the basics here. And then there's more to this, and you need to study the current version of the law and that type of thing. But anyway, hope that that's helpful to you, and I'll catch you guys in the next one. Okay, have a good one. Bye-bye.